All right, welcome everyone. My name is Angela Bull. I'm the CEO here at the Independent Book Publishers Association, and welcome to the third in our series of Selling Foreign Rights webinars for our Frankfurt International Book Fair participants. We've been on a journey together, and we still have a little while to go. I'm here with Terry Nathan from the IBPA office, who you know very well throughout this program. Hi, Terry.
Hello.
And also our guest speaker today, Jonathan Kirsch, is here from the law offices of Jonathan Kirsch in Los Angeles. Hey, Jonathan.
Happy to be here. Thank you, Angela.
Absolutely. And this is not our first rodeo, as you guys know, if you've been with us. You have purchased a package of, I guess I was going to say materials, but these are all kinds of different things. But you've purchased a package in the Frankfurt Book Fair program with us, and we're in the middle of this set of custom webinars where we're explaining how to license foreign rights and translation rights from a U.S. publisher. We had two of these sessions already with MJ Corshane, and we're here on the third session with Jonathan Kirsch to talk about the anatomy of a foreign rights agreement, which I'm going to continue to push through the chat as we go through this, and we'll pull up on the screen. But if you don't have it yet, please email Terry in the office and he can send you a PDF. If you're listening to this on record and you can't grab the chat, then make sure you get a copy of this agreement. It's very, very good. And you'll see Jonathan kind of walk us through the salient points today. I also wanted to point out in this kind of intro period, there's another exciting thing happening later today. The third part of your package is a listing on a dedicated website, which showcases all the titles that are available in this program. And I think, Terry, we have just under 200 titles in this year's program.
Yep, that's right, about 175, something like that.
That's a nice head shake. Very cool.
Yep.
So we have we are loading it on the Frankfurt Book Fair's Frankfurt Rights platform. We learned all about that last week with MJ. And we also, though, created our own website. We could have a unique spot for people to come to and something that's going to be available year-round for foreign rights agents to come and know what you have available. So we'll be able to send you this afternoon a link to that listing. You can check it out. Let us know if you see anything that needs to get updated typo-wise. But it should be pretty clean, and we're really excited about it. It's coming together really nice. So we'll be excited with you to see what that looks like. But today, of course, we are on the agreement, and we've got Jonathan Kirsch, who if you chat in, if any of you have worked with Jonathan or have experience with him. Jonathan, you've been the IBPA attorney for a minute. Doesn't say how long because I never.
Yeah, a long minute.
A minute. More than a decade. I'll give it that. Maybe two. I think actually, just to be clear, I think Jonathan kicked off with IBPA when we started back in the 80s. You were part of been part of this association since the very beginning. So not only does he have his own private practice where he focuses on publishing law and copyright and trademark and other intellectual matters, he is the attorney of record for the association as well. So we lean in to him for all of the questions that we have, and he's always been very helpful to us. And he reviews books, which I think is great. You know, he's on the other side of it as well. So he just gave us a recommendation for Gollum Girl, if I pronounced it correctly, the most recent one that he's referenced. And we have some people who do know you from IBPA Publishing University who've seen you speak there. So you do come and do a lot of education for us as well.
Great.
So Jonathan has developed not only our sample translation rights agreement, which we'll talk about today, there is also a sample publisher and author agreement on our website as part of your member benefits. So don't forget about that. It's the same format, so meaning very comprehensive, very long, with the marginalia describing the different points that you want to consider when you're building that contract. So we have both of those online today, and we'll talk about the translation rights one now, like right now. Let's jump into it. I think we're ready. But we have to figure out some tech stuff first, right? So we have to get Jonathan to share his screen so he can pull up a copy of the document.
Okay, I'm sharing. Thank you for coaching me through this.
You're welcome. And I see you're sharing some content. In the meantime, I'm again going to put the document in the chat so you can download it on your end if you want to get a bigger view. I will say to you that this might look small on your screen, there are little icons on the bottom right of the screen, little pluses and minuses. And Terry, maybe you could, do you see those little pluses and minuses so I know I'm not crazy and they're not just for me?
I see them.
Yeah.
You see them too.
Yep. So you should be able to plus and minus this to be a bigger or not bigger. You can see Jonathan is highlighting translation and publishing rights, the words. I just said, yes. Oh, do you want to know where this is on our website? Very good question, Thomas. It is, if you go to our website, and I'm not sharing right now, so take a visual journey with me, if you will. You go to the top left side, you'll see membership. And if you're in the membership drop down, you'll see member benefits. And you can go to a list of member benefits right off of the membership drop down on the left side of our website and go to list of member benefits. And under that list, you'll see this plus about 50 other different benefits that if you haven't checked them out yet, ooh, you have a fun day ahead, a fun day of reviewing all of those member benefits. So Thomas, maybe if you're off exploring the website now, chat back in if you found it. That'd be great to hear. All right. There you go. And Leslie's got us with the link. Thanks, Leslie, for your help. All right, I'm gonna be watching chat, Jonathan, and I want to turn it over to you with great thanks. Thanks for giving us an hour of your time. We really appreciate it.
My pleasure. Thank you, Angela. And thanks, Terry. Good morning or good afternoon to everyone. Happy to be with you today. I've been really looking forward to the opportunity to walk through and talk through the model contract that I've shared. I always like to encourage people to use these contract forms very thoughtfully and carefully. This is a complete contract. All the gears mesh. Inside the body of the contract, there are open and closed square brackets where information needs to be inserted for a particular transaction. But once those space holders are filled in, the contract will function. At the same time, no model contract or form contract is perfect for every transaction. And I've tried to guide you through the decisions and alternatives that you may need to make or want to make in the comments that you see in the margins. And we'll touch on some of those as we walk through it today. The first thing that I've highlighted is that a foreign rights agreement can be and often is two different kinds of agreements in one. Foreign rights are the right to publish a book outside the country where it was originally published. So let's assume for now that we are U.S. publishers. I know we have some Canadian publishers, and it's going to be slightly different for Canada. Strictly speaking, if you're a Canadian publisher, the United States market is a foreign market. So you need a foreign rights agreement to go into the United States. But that's a focus on a term that you'll see throughout this contract, which is territory. Where in the world are the rights to be exercised? So you could enter into a contract with a publisher in Spain, with a publisher in Germany, with a publisher in Canada. Those would all be foreign contracts. But they may not be translation contracts, because it will only be a translation contract if, in fact, the foreign publisher is publishing it in a different language. There are markets for English language books in the English language all over the world, and of course in all the English-speaking countries of the world. So, for example, an edition license to the United Kingdom is a foreign rights agreement, but no translation will be involved. I'm going to assume as we go through that the publisher is licensing both the right to publish in a foreign country and the right to translate and publish the translation. But there may be circumstances where that does not apply. The next question I want to...
I said I would raise my hand, and I might just have questions myself. I learned from all of these. If you assume that that's the case, you build both of those into the same agreement, then you build both. This
agreement contemplates both a foreign publisher and a translation. So if you look, literally, if you look at 1.1, that's a reference to the translation. In the margin, I've pointed out that if you are licensing English language rights, you would strike 1.1. You wouldn't use it. And there are other places in the contract where a reference to the translation could be stricken if the transaction was for an English language edition.
Great. Thank you.
Now, the question of language has become a very subtle and nuanced one in the world in which we live. I've done a lot of foreign licensing into India by U.S. publishers. There are 22 official languages in India. And by the way, there is a vigorous English language publishing market in India. But that is not one of the 22 officially recognized languages. And in fact, there are many more languages that are not officially recognized, but they exist. So one question that you need to focus on is the disconnect between the foreign territory and the foreign language. In any given country, there may be multiple languages spoken. India is the most dramatic example, but there are other countries where they might have both English, French, German. Switzerland is a famous example, 3 languages in Switzerland. And you want to be mindful of what languages you are licensing in any given market. There's also sometimes a territory that's much broader than the language. For example, if you're licensing Spanish language rights, that encompasses rights in Spain, in Mexico, all over Latin America. And you may need to or want to divide up the territory among Spanish language publishers. And then just this week, or late last week, a whole new issue came on my radar, which I'd never encountered before. I'm accustomed to India having multiple languages, but I have a publishing client here in the United States who has licensed a Spanish language edition in Spain, which regards its version of Spanish, Castilian, as a different language than the Spanish that's spoken in Latin America. And so it's possible to say to the Spanish publisher, I'm going to give you rights in Castilian, and you could publish that Castilian edition in Spain only or in Spain and Latin America. But I am reserving the right to authorize a Latin American Spanish edition that broadens the market that the publisher is able to monetize, assuming you find publishers, foreign publishers who are willing to accept those kinds of limitations. 2 more issues, and these are strictly administrative issues, but they're very, very important. If you are the publisher, you have to satisfy yourself that when you acquired the right to publish an author's book, you acquired the foreign rights from that author. You have to go back to the author-publisher agreement and make sure that the original deal transferred foreign rights to you. Some authors decline to grant their U.S. publishers all languages, or for that matter, all territories. So you don't want to find yourself in the embarrassing position of entering into a contract with a foreign publisher and then finding out later, or coming to the realization later, remembering that you didn't have those rights to begin with. And then a similar issue, I have many clients have very, very active foreign rights programs, and they license many, many editions. So you need to keep track of where you have already licensed an edition, whether by language or by territory, to make sure that you don't enter into a second contract in the same market or for the same language. Now, we've already touched on this, but I want to emphasize it. If this is a contract for a publisher to translate the work into a specified foreign language, a second work of authorship that can be separately owned under copyright will come into existence. The original book, let's assume it was written in English, is a work of authorship. The translation is a separate work of authorship. It exists independently. And it will have a different owner in most cases, unless the contract says otherwise. Now, a translation is what we call in copyright a derivative work. So the derivative work can only be used if the owner of the underlying work gives permission. So it seems self-evident, but I'll say it out loud. I can't sit down and create a translation, the copyright to which I will own, and then publish that translation. I need the permission of the owner of copyright in the underlying work. Where this comes to your attention is at the end of the contract term. What happens to that translation when the foreign rights agreement expires? I have included a feature in this contract that allows the U.S. publisher to go back to the foreign licensee and essentially buy the translation at cost, buy the translation at the same price that the foreign publisher paid the translator in the first place. This means that you will have a serviceable translation that you can offer to the next licensee. So it's advantageous to you. It also kind of raises everyone's consciousness that that translation can no longer be used by the former licensee. If you do not acquire the copyright to the translation, it will continue to be owned by the foreign publisher, but under the laws of copyright, it cannot be used. It's essentially on ice until a license is granted by the owner of the underlying work. Okay, the next thing I want to focus on. It is typical in my experience that the U.S. publisher simply sends a digital file to the foreign publisher with everything that's in the English language edition of the book. And the foreign publisher, as in this example that I've highlighted, foreign publisher is entitled to use it all. Everything that's in the book, on the book, in its edition, whether that's an English language edition in a foreign country or a translated edition in a foreign country. There's a trap there, and it's especially applicable to covers. Covers are often acquired by the U.S. publisher from a designer pursuant to a limited license. And you have to go back to that license and make sure that you have the right to use the cover abroad. You may not. There was a period in history where, in the early years of the audio publishing industry, where the cover of the audio edition was routinely different than the cover of the print edition because the publishers were not asking for the right to use the cover artwork on an audio edition. And the designer of the cover was likely to say, I want to be paid again separately for the right to put that image on a audiobook. And if someone, either the licensee or the original publisher, didn't want to spend the money, then a different cover would be used. The same issue arises in foreign publishing. And it applies not just to the cover, it applies to anything that's third-party content that you acquired from a third party and you are now allowing someone outside the country to use. Now, this is a value-added, updated issue, which I thank Angela for prodding me into adding to the contract. There was a previous version of this contract that dated back a few years. And when I addressed the issue of what format the foreign publisher could publish in, it referred only to print. There are reasons why, and mostly historical reasons, but it was pointed out, and I was requested to broaden it, and so I have broadened it. The authorized format is something that can change from contract to contract. In this contract, as you can see, there are 4 basic formats that are authorized. Conventional printed books in any format of printed books, a hardcover, trade paper, or mass market paper. POD, ebooks, and audiobooks. This is a menu of rights. You may not be comfortable, for example, in allowing ebook rights to go into the hands of a foreign publisher in a distant market that you can't effectively police, because ebooks are very, as you I'm sure already know, are very easy to copy and hard to get out of the market if they are copied. So you may decide that you're not comfortable in an ebook edition with a foreign licensee, and if you aren't, then you can negotiate a different package of rights, and whatever package of rights you are willing to grant should go in and be clearly defined in the contract, and they are what I'm calling in this contract authorized formats. This is what the foreign publisher can do. Now, I've already previewed the next issue, which is territory.
I have one.
Yes.
Question on.
Sure.
I have a question on this point. Why are you differentiating between a print on demand and like an offset print? Why is A and B 2 separate options when that's just like a printing function?
It's a very astute question. It's a very astute question. When POD first emerged as an available technology, it was not regarded as a publishing technology by the book trade. It was something less and something different than a printed book. And so I took the position as an attorney drafting publishing contracts that if the publisher wanted POD rights, wanted to do less than a real printed book that would be in inventory, that right should be specifically defined. I concede that since then, since the first emergence of POD is widely used, commonly used in trade publishing, and is no longer a separate and different form of reproduction. And the lesson that I learned is when contracts were first being drafted for printed books since the age of Gutenberg, printed books were type against paper. When it went to offset printing, that wasn't a new technology that required a new contract right. It was just another way to print. So if you had the right to print books, you could print books with lead type, or you could print books with offset. I'm convinced that POD is now in that status. But as we know, it changes the whole dynamic of the transaction between the person granting rights and the person getting rights. This mostly comes up in our experience with authors who used to be able to say, if you went to the trouble of turning on the printing press and printing a commercially reasonable supply of inventory and you put it in your warehouse and you could fill an order today or tomorrow, then you can continue to have the rights, and if you no longer go to expense of printing it and inventorying it, you lose the rights. It's out of print and the rights revert. And the authors will commonly say, POD means that you're never out of print. And that means it becomes a perpetual contract, which that strikes the author as unfair and is contrary to the long established custom and practice of publishing. So we've solved that problem in the author-publisher contract by putting performance benchmarks when the book is available only as an ebook or a POD book. Commonly, the author will say it reverts to me, even if someone can buy a single copy POD or a single copy as an ebook, unless the publisher has sold a certain minimum number of copies or paid a certain minimum amount of royalties. That's when it's the publisher dealing with the author. Well, now we have the publisher dealing with another publisher. And the question that you have to ask yourself is, are you, as the U.S. publisher, comfortable in tying up the rights in a foreign country for years? And we'll get to that point in a minute. Even though they're selling one copy at a time whenever someone bestirs themselves to buy a POD copy. The economic value of that transaction for the U.S. publisher drops dramatically. Mm-hmm. So this is a financial issue, and if you as a publisher are not comfortable in letting the foreign publisher have exclusive rights to the book in a particular market for a particular amount of time, even if it's just a POD, then you can either take POD out entirely, or, as this contract does, you can require a minimum printing by conventional offset or conventional printing. And that's what I recommend.
Great. Thank you for that.
Yeah,
pulling
sure.
that out. I will ask one more question and then
sure.
move you through.
Go ahead.
Marta is talking about the cover situation and who owns the copyright on the cover, and she has an example. I'll read the example. Does the cover situation apply if the cover was work for hire and the author, who has given us the right to license overseas, owns the copyright? So the author.
The answer to that question, and it's an excellent question, is no. If the current copyright owner of the illustration of the artwork owns that artwork as work for hire, they own every right under copyright without any exception whatsoever. Right. So if I, as the author, acquire artwork on a work for hire basis, I can exploit that artwork anywhere in the world in any medium for as long as it's under copyright. So that's a very appropriate question to ask. But you're asking it of the person who's granting you the right to use the artwork. If it's the author, you want to want to satisfy yourself that the author well and truly has ownership as work for hire. You might ask that author to show you the agreement by which those rights were conveyed. Now, I don't want to get too far off track, but the author-publisher agreement has representations and warranties. The author is asked to represent and warrant to the publisher that the author has the rights that the author is giving to the publisher, and to indemnify the publisher if he or she didn't have the rights. So you have legal guarantees in a conventional author-publisher agreement. But it's also, what Reagan said, trust but verify. It's worth asking about.
I literally just typed that in the chat.
Yeah.
Yeah, exactly. Very good.
Now,
thank you. Thanks, Marta, for that question.
Sure. Let's go to territory. I've already previewed this to you. Territory is a separate variable from language, and you need to be thoughtful about what territories you're granting and how you're defining them. So, for example, a contract that says North American rights is a territory that arguably includes Mexico, the United States, Canada. I'm not sure, frankly, I'm just not sure how some of the countries of Central America would fit into that. It's better to list countries as countries, except when it comes to the European Union, that's a recognized group of countries. But you want to be clear enough that if a question arose later, you'd have an answer to it as to what particular markets you have committed to a foreign publisher and what particular markets are still available to you to commit to a different publisher. And this becomes even more pointed when you're licensing foreign rights in the English language. We used to, and you'll still see contracts that refer to the British Commonwealth, something that doesn't really exist anymore. And the Commonwealth is it's a moving target. It has different countries in it at different periods in history. That's another invitation to ambiguity in the contract. The best practice is to define the territory by sovereign nations, by their country status, except when it comes to the European Union, which does have legal recognition. And then now you've set the bounds. When you define the language and you define the territory, you've set the bounds within which the foreign licensee can exercise the rights that you're granting. And you have defined the territory that's available to you to license to someone else. So these are important variables.
And those countries that have purchased these rights from Leslie, they are not, just to put a pin in it, I suppose, they're not getting the right to sell the original ISBN, the English version, the U.S. publisher published in those countries as well. So
let's talk, this comes up a lot in my practice. Let's talk about what an ISBN is. An ISBN is a stock keeping unit. It is an inventory control number. It's nothing more than that. It has nothing whatever to do with ownership. It has nothing whatever to do with copyright. It identifies a particular edition of the book by a particular publisher. And ISBNs are publisher-based. They're issued with a base number that's unique to a particular publisher. So if U.S. publisher licenses a Spanish publisher, the Spanish publisher will publish it with its own ISBN number. The two editions will have different ISBN numbers because they're different editions and they're different publishers. So the ISBN does not travel with the book rights. They are unique to the publisher. Okay.
I'll put in the chat there's a really technical U.S. guide to the ISBN. I'm going to put it in there for the geeks like me that like to read up on ISBN. So continue while I geek out.
It's a subject of much confusion in my experience among authors who think that when the rights revert, the ISBN should revert. And that's a fallacy because the ISBN belongs to the publisher. The publisher shouldn't use that ISBN anymore, but it's not something that has anything whatever to do with copyright. Okay, we're looking at the term. This is a very important point and something I want to highlight. In the custom and practice of the foreign rights industry, rights are licensed rather than assigned, and they are licensed by a specified term of years. That doesn't mean you couldn't enter into a foreign rights agreement that was an assignment. You could do that. An assignment would convey ownership of rights and not merely the right to use the copyright, but it would be very unusual. It would be assigning to the foreign publisher the ownership of the copyright. Most U.S. publishers will do nothing more than a license for a term of years. That means the copyright is owned by whoever owned it on the day the license was signed, whether that was the author or the publisher, and it can be used by the foreign publisher during the term. The term of years is a negotiable point. We see the question just came up. I've given in my model contract 3, 5, 7, 10. I'm going to say that 3 is an unusually short period of time. It would be very, very unusual to see a 3-year license. Part of that reason is that some time is going to be eaten up with preparing the translation. So the amount of time that's going to be available to the foreign publisher to actually publish the translation would be insignificant. But I put it in there just to show you the range. I would say 5 years is the most common term that I see. 7 years I regard as longish. 10 years I regard as really long. But again, it's a deal point. And if it's an advantageous deal for you, the U.S. publisher, if the foreign publisher is capable and trustworthy and has performed well on other contracts, is prominent in the market, a lot of these factors are economic, you may be willing to say, I'll give you 10 years or even longer. And that's a decision you make. But whatever you do, you're tying up what are potentially valuable foreign and translation rights for the defined term. Now, the most important thing that I can highlight here is the contract I'm presenting to you automatically expires at the end of the term. This I very highly recommend, even though a lot of foreign rights contracts have automatic renewal clauses. The problem with an automatic renewal clause is that if that notice date, the date by which you must notify the other party of non-renewal, if it gets past you, you're stuck for the same number of years again. So if you have an unhappy experience with a foreign publisher and you have an automatic renewal clause, and these typically are 90 days ahead or even longer, ahead of the expiration date of the first term, and you're not watching that calendar carefully, you may end up in business for another 10 years with the same unhappy foreign publisher. So I don't like automatic renewal clauses, and I recommend against them, but I don't deny that a lot of them are out there.
Can you respond to Carl's question since you're just in this
Sure.
right now? So he says, can you set the starting date of the contract to begin after the product is print ready, I'm supposing in the foreign country?
The way, you certainly can. You certainly can. But what this contract does, and if I travel through it, I can point it out. This contract says the maximum term is X. It has a beginning and an end. Let's say it's 10 years. And within that 10 years, it sets a publication date by which the publisher must publish. Now, what does that do? That says to the publisher, if you fail to publish within the time agreed upon, you're going to lose these rights, or at least you're at risk of losing these rights. And it also says to the publisher, your opportunity to sell copies at a profit begins after publication. So it motivates the publisher to be expeditious, the foreign publisher, to be expeditious about getting its edition out. That's how this contract is structured. It says 10 years, let's say 10 years. It says X years, whatever X is, and you must publish within 180 days or a year or whatever it is. And then if the foreign publisher comes back to it and says, well, it's going to take me longer than you are allowing me to get in the print, and that means I won't have very much time left to publish, you could adjust those numbers. You could give the foreign publisher a longer period to get to market, and you could give the publisher a longer overall term. So it's a nice, neat little package. Now, you could draft a contract that says your exclusive rights to publish begin on the date you publish. The contract doesn't begin on that date. The contract has to be in effect on day one. It must be a present and existing contract. So you can't use language like the contract begins or the term of the contract begins on publication. That means that prior to publication, there is no contract. I prefer the format that I have embedded in this document. And if you choose a different format, you have to be very careful that contracts exist and is binding on day one. The period of time during which the foreign publisher must publish is defined, and the period of time during which the publisher can sell is defined.
Got it. Thank you. And I have a couple other questions that are coming. I'm kind of holding them and hoping we'll have probably 10 minutes or so at the end to just do questions. If that works? Okay.
That's fine.
Great.
The next paragraph that I've highlighted is exclusivity, just to remind you that you're giving an exclusive within the variables of territory and language, and during that period and in that country and in that language, you can't relicense the rights to someone else. But if you're careful about how you define those things, you should be able to preserve other markets that might be valuable to you. We've talked about that, markets of language, of dialect, physical countries. Much of what you're seeing here is mechanics about delivery. All of the clauses regarding the translation are technical. They set standards of professionalism and competence. The catch, which should be obvious to you, is although this contract allows you to review and approve the translation, and so if it's a bad translation or unfaithful translation, or if extraneous material has been inserted, in theory, this contract allows you to disapprove the edition, and then they can't publish it. The problem being that you then need a translator of your own to assess the quality of the translation that's been presented to you by your foreign licensee. I have clients who are very, very concerned about accuracy and faithfulness of translation, and they prefer to commission their own translations. And they authorize the translation of what they have satisfied themselves is acceptable. That's a small number of clients that do that. You probably don't want to go to the expense of commissioning a translation. And if you don't, you're going to be taking at least a theoretical risk that you're going to end up with a translation that's inferior in some way. Paragraph 7 prescribes what the licensee, the foreign publisher, must put in the book. These are very customary. Paragraph 8 is the approval clause that I've mentioned to you. Paragraph 9 is the clause that addresses the POD issue that Angela brought up. This obliges the foreign publisher to print a defined number of copies at first printing and to maintain it in inventory, to print additional copies throughout the term. This clause, as drafted, would prevent the foreign licensee from just having a POD edition. So you could authorize POD, but as long as you have something like Section 9, as I've highlighted it, it cannot be only POD. If it's not in print in the conventional sense, then you can terminate. I'm going to highlight this word because it is still a custom and practice in foreign licensing for the foreign licensee to calculate royalties based on retail price and not on net revenues. I am convinced, and I often tell people, that in the publishing industry, SRP is a thing of the past. It's largely symbolic where it is used, and that U.S. publishing, as between the author and the publisher, is shifting definitively to net revenues. In foreign licensing, it is my experience that foreign publishers are still willing to pay a royalty based on SRP. That's hugely to the advantage of the U.S. publisher, because you are going to be so distant from the transactions. I'm sorry, is that a question? No, I'm sorry. You're going to be so distant from the foreign publisher, the transactions, the markets, that if you were being paid on net, I fear that you'd be at great risk of getting an undercount. I have a client who told me that they have a very valuable license in place in a very big country. I'm going to be discreet and not mention the country. And they have been informed by a whistleblower that they are routinely being underpaid 20% every year, year after year. Somebody inside the foreign licensee tipped them off. And it's interesting that the revenues, even with the 20% undercount, are so significant that they're willing to live with it. They're not going to make a fight about it. But even if they wanted to make a fight about it, that's the problem with foreign licensing, is that you have to go, you could sue that company in the United States, but if the company has no assets in the United States, that's not going to do you any good. You have to go to the foreign country, hire a lawyer in a different language and a different judicial system, and it's very unappealing. So the clarity and the certainty of suggested retail price bestows a great practical benefit on the U.S. publisher. There are termination rights in this model contract, that's what I'm highlighting now, that are very rigorous, and I think they're conventional, they're customary in these kinds of contracts, and very, very important as a practical matter, for the same reason I've just discussed. You're at a disadvantage in dealing with a company in a different, far away physically, in a different language, in a different legal system. And so it's important to have the right to terminate with bright lines. And one of the bright lines in this clause is if they don't publish by the date when the first edition must be published, or if they don't keep it in print continuously, you can cut the cord. By the way, there is another, and I see that our time is growing short, and I want to make sure I make this point. One of the great advantages of having a licensee in a foreign market is that you now have someone with a stake in keeping infringing editions out. You might not even see the infringing editions in the foreign market unless you had a licensee who was physically present there and had a stake in keeping them out. What I've often said to clients is, even if the foreign publisher in some particular exotic foreign market is making a less than attractive offer, the advantage of having that a licensee in the market may itself be worthwhile, if only because that publisher may be tomorrow's infringer. They may say to themselves, oh, well, we couldn't get the rights, but let's publish it anyway. And then you're at a disadvantage in going after that publisher. I once had a client who sold a book in English. It was the English language rights to India, a country with more than 1 billion people. And when we were negotiating the minimum print run, the Indian publisher said 300 copies. And I mean, I was aghast because I didn't think they were going to turn off the printing press after 300 copies. I feared that they'd print as many copies as they could sell and report 300 in sales. But I still said to the client what I've just said to you, which is that you may find even that meager deal to be better than no deal, because the same publisher might do it without a license. Okay.
So I'll have you call out the last and the big points on the contract, and then I want to rapid fire some questions to you.
Why don't we go to questions? I think I covered the big points.
The big salient points? Okay.
Yeah.
Okay. I'm going to become the presenter then. I'm going to take all that privilege right away from you. All right, cool. Let's go to questions. One is from Leslie. I think it's a good one off of just going off what you had said. We all know, based on MJ's presentations over the past couple of weeks, that the publisher selling the rights is the one that develops the contract, which is why we've given them a template contract. But what constitutes an attractive offer? How would they know what to offer? I think the answer is the foreign publisher is going to tell you what they want to pay. And
yeah.
You can negotiate all of that before you draft the contract, but the offer is going to come in from the foreign publisher.
It's true. I would say two things. I see 10% a lot. I see 10% as the base royalty a lot. So I tend to think of that as kind of a default mode royalty. I've seen them lower. I've seen them at 7 or 8%. I've seen them lower than that. I have one client who licensed an English language edition of a book to a publisher in England in 1952 for 15 cents a copy, and a stated royalty of 15 cents a copy. And we could never, it was a perpetual license. And we're 50 years more, 70 years later, and still getting 15 cents a copy. So you want to be careful in how low you go and how long you commit to. And that's one of the advantages of a shorter licensing term. If the foreign publisher is offering you what you think is an inadequate percentage, you can give them a shorter term, and if they're not selling enough to justify the low percentage rate, you can find another publisher who would. Yeah. Another approach that I recommend, it's very advantageous to the U.S. publisher and very disadvantageous to the foreign publisher, but it has a lot of benefits for the U.S. publisher, is to say to the foreign publisher, you are required to print X number of copies in your first printing, and the advance will be equal to the payout, the royalty, on those 1,500 copies. So you're essentially prepaid. The royalty is prepaid as an advance. And I've even written contracts where every time they go to press, they have to prepay. But that's a very rare deal. Very few foreign publishers will do that.
Mm-hmm. I think that leans in a little bit into Maryland's, no L in there, but question about how much money is standard for countries. There's no database that you can check to see what is standard across countries, and it all really depends on the book too, and how many copies have sold.
That's right.
Just how it
now, if you're working with a foreign rights agent, they'll have a lot of information. If you have yourself been in the foreign rights market and have gotten offers, you will have experience. And the longer you are in the foreign rights market, the more experience you have. But if you're doing your first foreign rights deal, then what I tell, this is probably the single most often asked question is, what's the right price? And the cruel truth is the price that someone is offering is the market price until you find someone else who offers more. So you may be in the uncomfortable position of saying to the foreign licensee, that's not enough, and they say that's all we can pay, and then your choice is to keep it keep it on the market, or take a less than attractive offer. Mm-hmm. That's a tough decision to make.
And just to confirm, advances can be offered, but MJ did talk the last time about often in the indie press world, you're not really looking at advances as much. You're looking at a % royalty. But they can be offered. I mean, foreign publishers do pay advances as well as royalties on these deals.
Well, absolutely. Publisher to publisher, the foreign publishing deals, in my experience, advances are very common. Now, it may be that if the foreign publisher is an independent publisher and the U.S. publisher is an independent publisher, that the dynamic is such that there won't be a lot of liquidity on either side, and they may not be able to come up with the advance. That's, again, driven by the market. If you have someone who will offer an advance and someone who cannot offer an advance, if you're lucky enough to have both offers, well, clearly you want to go with the one who will pay an advance.
Mm-hmm. That's the best thing. Like, I'll take that with me from this. A lot I'll take, but one is the price is what people will pay. Kind of,
that's exactly.
The price. That's the right price. David asked this question in here twice, and I think it's good. Can you talk about how having Amazon selling English copies in a foreign market impacts selling foreign rights in the same?
Well, that's a very good question. Amazon should not be selling English language copies to foreign markets unless you have authorized them to do it. And they, as much as you can make Amazon do anything and obey the law in any way, Amazon will honor those kinds of boundaries, and they won't fill orders from foreign buyers if you have granted those rights to someone else, for example, which would put you in breach and put Amazon in breach of the rights of a foreign publisher. So that Amazon is a separate reseller, and that's a separate problem to be solved. But you have to be vigilant there too. When you make books available for purchase through Amazon, you have to define the selling territory that Amazon can address.
I know you do that. If you're POD through Ingram Spark, there's a massive spreadsheet you have to fill out to tell them exactly which markets you're going to sell to and what price you're going to charge in each of those. So you just have to keep track of that. And if you end up selling in a market, you have to go back into your agreements with your POD or whomever, wherever you are, and take it out of that market.
That's correct.
There's a question on the agreement itself, which is an interesting one, just how we use this sample agreement. And I'm going to ask it in connection with how much would you typically, I don't know how this question, how much would you typically charge, would it typically cost you to have a lawyer draft an agreement for you or to work?
Let me tell you what I charge for the sake of transparency and candor. My hourly rate is $4.50. I cap my fees for drafting a contract at 2 hours of my time. If it takes me less than 2 hours, I'll bill at the hourly rate in quarter-hour increments, but I will never bill more than 2 hours. So, for example, if one of the members of IBPA came in and wanted a custom drafted contract, or wanted me to revise their contract, or wanted me to revise one of the forms that they find online, whatever the starting point is, it will never be more than 2 hours of my time. I'm not sure what other lawyers are doing, but that's what I'm doing.
Thank you for the transparency. There is a list of lawyers, and Jonathan is on this list. And also, by the way, and thank you to Jonathan, he's actually helped us to make that list more diverse. So it is a list of lawyers who work on publishing issues pretty much exclusively, and you can find that in your member benefits handbook, and you can ask around. But you do say in our contract that you should even not use anything really. You should get a lawyer to review it anyway. I think Carl's question is, if you're going to use this contract, can you just strike things out so you don't have to change the numbering? So
I see that question. It's an excellent question.
Yeah.
Here's how I would answer the question. In my long experience in publishing, the standard usage is you adopt a contract form, and in any particular deal where you are making concessions in your standard contract form, you strike out what's being deleted with just put a strikeout on it, and you insert in a different color, it's often bold, a different typeset, often bold, what you're adding. But you do not redline. You do not use word processing changes, because if you do, every time you pull a contract, you're going to be guessing what's in it. If you use your standard contract, you can, and you have highlighted it in the way that I've described to you, you can instantly tell what's different about this deal. And I recommend it, and I use it. And most of the publishers that I learned about the custom and practice of the publishing industry from 30 years ago used it, even before the era of word processing. Now, there's a slightly different issue, which is, what do you do with the model contract? Well, you could go through the model contract and customize it, fine-tune it, tweak it, change it, and you would do that in word processing. So at the end of the process, you have a finished document. But once you have a finished document, if you then negotiate changes with any particular licensee or author for that matter, my recommendation is to highlight it manually so that the highlighting is embedded in the document.
Got it. That's good to know. And quick yes or no, are rights contracts between U.S. and foreign publishers, when they originate with the U.S. publisher, or I guess vice versa, are they always in English?
Very good question. In China, there is a law that contracts must be in, they can be in English, but they must also be in Chinese. And if they are disputed, the Chinese version controls. That's the national law of China. In most foreign transactions that I am personally familiar with, the contracts are typically in English. There's no such provision in the national law, and if it's litigated, it'll be litigated in the English version. Now, where it's litigated is a different question. You can say in your contract that the United States is the venue for where the lawsuit takes place, and it provides the jurisdiction, the courts of the United States, and it provides the applicable law. And many foreign publishers will agree to that. It's a disadvantage if you have to go to, obviously, if you have to go to another country to litigate.
Thank you. Can I ask for 5 more minutes of your time?
Absolutely.
Okay, so I want to acknowledge that we're going to go a little bit over at 11. I'm going to ask just 3 or 4 more questions quickly, and then I really want to respect the rest of your day, which, they've been busy. These days have been busy. So from Maryland, I will always say your name wrong, Maryland, but that's what it looks like to me. Is there so if there's an English version that you're selling in France, because a lot of people in France speak English and you're selling it there, will the foreign language publisher still want to publish it in their native language? So will somebody buy it and publish it in French if you're selling the English version in their market?
Well, I'm going to answer that in 2 ways. In theory, you could license one French publisher to publish a French edition and another French publisher to publish the English edition in France. You could do that. The publishers might not be happy about that. And so my recommendation is that if that's the deal you're making, that you put that in the contract itself. So if you're making a contract with a French publisher for a French edition, the contract should say, U.S. publisher reserves the right to license an English language edition in the same territory, and vice versa. Now, the same publisher may want both languages. And that's, in my mind, that's better. It's confusing to the market to have the same book available from 2 different publishers. But it's really a sense of the market and what market the foreign publisher is addressing. If the foreign publisher is a bilingual publisher, then that's a natural home for both the English and the foreign language edition. If that publisher publishes only in the national language of the country it's located in, then they may not even be interested in an English language edition.
Right. So, I mean, what I hear is anything's possible, right? Like everything is sliced and diced down to the minute.
You can negotiate anything.
Yeah,
but I pointed out an exclusivity clause in the model contract, and this is an example of where, strictly speaking, you don't have to say to your French publisher publishing in French that you may go back into the same territory and offer someone else to publish in English. You don't have to say that from a legal point of view. But from a business relationship point of view, it's really smart to do it so you don't get an unpleasant phone call later on when they discover the English language edition.
Yeah, you are in a partnership. So to Leslie's, I think that's a very interesting idea. Is it common to retain and or purchase the rights from the foreign publisher to sell their translation in your territory? So you might take a Spanish publisher, they can sell the Spanish rights in Spain, but then you buy that Spanish translation and sell it in the U.S.?
As long as you have excluded the U.S. from their market in the negotiations, it's entirely appropriate and should be unsurprising to the foreign publisher that you're interested in using their translation in a market they're not getting. It shouldn't be an awkward moment because their turf, the place where they're going to sell it, has already been defined.
But you can then buy their
in negotiation. You can certainly do that. But I'm going to tell you what I learned recently, and I already mentioned it. If it's a Spanish translation in the Castilian dialect, it's not going to be appropriate for North America. It's a different language. And you'll need to retranslate it. But you can certainly say that to the foreign publisher. You could say, I would like to buy or license from you the translation that you're preparing, and I'm going to license that translation in markets that I'm not giving to you.
Interesting.
So that foreign publisher may say, well, I want those markets too. Give me those markets. I'll monetize the book in the foreign That could happen.
Mm-hmm.
There's nothing off-putting about asking that question.
And then someone had advised at One Frankfurt over the years, though, that it could be that foreign publisher, because that is their native language and those are the native markets in which they typically work, may do a better job selling into those markets than a U.S. publisher with no experience in that space.
No question. I think it's always better, always, invariably, to have a foreign publisher who knows the market. The question that you've raised, though, is, does a publisher use this as an example, does the publisher in Spain have experience selling into Mexico, for example, or any other country of South America or Central America? If they don't, if they're not publishing in other Spanish-speaking countries, then they don't have that expertise that you're looking for. You may want to go to a Mexican publisher for the Mexican rights.
Got it. So many deals. Let's see. This is one about, so you've already printed a bunch of books. Is it permissible to sticker over a POD barcode, well, I guess any barcode, an ISBN, with a unique barcode and alternative ISBN for the international?
Well, let's be careful. If you have bought a remainder edition from a publisher who's no longer publishing that book, then stickering it with your ISBN and your publishing imprint is permissible. But you should make sure that the publisher whose edition you are now restickering doesn't have continuing rights, because you may be infringing their rights by restickering.
Mm-hmm.
There's the way to give you a clear example. Let's say at the end of 7 years, there's a 7-year term, and at the end of 7 years, you have the right to buy their inventory. That's in the model contract. Whatever their unsold inventory is, you can buy it. And you can import it to the United States, and you can resticker it and resell it or re-export it somewhere else. All of that is permissible at the end of the term. The question is, if their rights it's the middle of the term, and you're buying and restickering their books, I think you're probably in breach of contract. Depends what the contract says. You could write a contract that allows you to do that. Right. But I wouldn't assume that you're allowed to do it.
Right. So the permissible is, again, everything kind of comes back to the contract.
Yeah.
Is it permissible? What does the contract say?
That's exactly right.
But stickering over barcodes, I do not enjoy it as a person who likes very orderly things in life, but it is absolutely a common practice in our industry that if you need the barcode to be different and you don't want to reprint, you can buy stickers and put them over that. And they're very, very sticky stickers. It's not like something your kids would use. These are things that do not come off easily. Well,
as I say, I don't think there's anything inherently wrong with doing it, but you have to look at the underlying contractual relationships to make sure that you're not passing off somebody else's book as your own in violation of a contract.
Got it. Okay, last question. And
Wait, I have one too.
Two more questions. This one from Robert. We get stuck on retail price, net price, that kind of a thing. And I'm just going to read it verbatim because I got stuck not understanding it initially. Does the retail price include any sales discounts on the book?
No.
Or is it the retail
by definition, suggested retail price or list price or catalog price all mean the same thing. They mean the price set by the original publisher, and at least in the old days, the price printed on the book. That's not always the case anymore, but it used to be the suggested retail price was printed on the dust jacket or on the cover. That's the retail price, suggested retail price, list price, catalog price. And it's without deduction. And as we all know, it's not a price that anybody really ever sees. Even the reseller is likely to be discounting to the consumer. So it's a theoretical price rather than an actual price, but it's a benchmark price for calculating royalties. It can be used as the benchmark, as it is used for the calculation of wholesale discounts. Just an artificial number that you use as the starting point in calculating the selling price at wholesale, and it's a benchmark number that you use for calculating royalties.
So I'll say this. I'll say it myself just to clarify. The price you're saying that, and you can do it either way. You can either use list price or you can use net price to calculate royalties. But the way the industry is leaning currently is to use list price at this point
I would say that
rather
that's
the other way around.
I'm saying it's a tradition or a custom and practice in foreign rights transactions.
Got it.
And it still is what I see most often in foreign rights agreements, and it is hugely to the advantage of the U.S. publisher because of the complexity of understanding whether you're getting an honest count of net revenues.
Right, because how do you know what they're discounting, where, how much?
Exactly.
Yeah, exactly. Interesting. Well, to answer to Marilyn, I was kind of wrong. Jonathan did say that it advances. He does typically see advances, but again, everything is negotiable. So you'll see what happens when you start to get offers in. And then I said one more question. Sorry, Nathan.
Sorry.
No. Hey,
so, Jonathan, I'm just curious about first right of refusal. Sometimes these international publishers need to take some time considering the book. But they don't want somebody else stepping in and publishing it from under them as they're considering it. Is it something common that you see? And do you usually, is there a quick agreement that you put in place with somebody to give them the first right of refusal? Well,
first of all, I don't often see it. I can't. Let me be more emphatic. I have never seen it.
Oh.
Where the foreign publisher asks the U.S. publisher to hold the foreign rights off the market while they think about it. I have never seen that in a formalized agreement. It's entirely possible that you might be motivated to say to the prospective purchaser, I'll give you a week or I'll give you a month or I'll give you 30 days, whatever, and I won't sell it during that period. And if you're willing to do that and they say, yeah, I want you to put that in writing, that could be put in writing. So what you're doing is taking it off the market for a defined period of time for no consideration, for no compensation. You might be willing to do it, and if you're willing to do it, you might be willing to confirm it in writing.
Okay.
Technically, a right of first refusal is a little different than just holding open an offer. I would call that a period of exclusive negotiation. You could say, I'm going to give you a 30-day period of exclusive negotiation. I won't close a deal with another publisher for 30 days. That it strikes me as reasonable from a business point.
Gotcha. And then actually one other thing was, are reprint rights and publishing rights the same? Often in India, I hear people asking about reprint rights because they print on a much lesser quality stock paper in English, but it's they've always termed it as reprint rights. But is that one and the same?
Well, reprint rights, in that sense, are rights defined by the book format. You know, there's back in the old days, before any of you guys remember, U.S. publishers would typically buy hardcover rights only, period, just hardcover rights. And paperback rights were reserved to the author. And if the book was a bestseller in hardcover, the author would go into the market and try to make a paperback deal. And paperback deals could be huge, very significant amount of money. It was like their second shot. That was very common in the old days. Nowadays, that distinction has gone away. But if you said to a publisher, I'm going to allow you to do only a mass market paperback, or what's sometimes called a cheap edition. In some contracts, it's called a cheap edition. But I'm going to reserve the rights to do a hardcover. That's fine. That could be separately licensed. Now, I don't think the phrase reprint rights tells us enough to know exactly what kind of deal we're talking about. Reprint to me means the book was originally published and now is being published again by a different publisher in a different format That's what I think it suggests.
Great. Thanks, Terry. And thanks, everybody. Those of you, almost all of you, who stuck with us to the very end and beyond. I really appreciate that. And Jonathan, as always, I learn something every time I come into a session, and really appreciated that. Thanks for sharing some of your expertise with our membership.
Well, thank you. It's been a pleasure. Happy to be part of the group.
Awesome. Thank you very much for your time. And thanks, guys. Jonathan, we'll let you go. I will
Okay.
hang here for a second.
Bye-bye. Bye-bye. Be well.
Be
well.
Thanks, Jonathan.
Thank you very much, sir. And thank you, Terry, for coming in. We're still sitting here. So if there's a question about the program that you want to chat in, if you want us to unmute your line or do anything, we will be here for a couple minutes just to make sure we have a little FaceTime. Might as well use the time. I did mention that we are hard at work getting your metadata up on the two websites. So you'll see a version of the IBPA branded site today, this afternoon. And Frankfurt Rights is coming along, I think, Terry. You're starting today, or no, today's the day where everything.
Yeah, we're getting it all figured out. They opened it up a little later than we had hoped, but we'll be getting it up there really soon.
Okay, and we will get some notes out to you about that. We did send, or Terry did send, a more detailed, description of how this program runs based off last week's session, where there was some questions just basically about what are we doing versus what are you doing. So that email you got last week from Terry was our attempt to clarify some of that stuff for you. If it didn't clarify, definitely let us know, because we want to make sure that you guys have the information that you need. Let's see if there's any other questions. Linda says, I understand that Amazon and Ingram Spark territories can be changed. Yes, they can. All metadata can be changed. Not, always the most intuitive, but just know that it is possible, Linda. You can go back in and you can change those territories.
What was coming to mind for me when we were talking about that was it's not all that different than if you signed on with a distributor here, your distributor would want to sell to Amazon, and you would need to redirect things through them rather than selling them direct. So it's not uncommon. Same thing with international markets, I think. You would just need to pause, take certain markets out of your wheelhouse and hand them off to whoever it is that you're working with.
Great. Awesome. Well, I don't really see many other questions, so you guys know we're accessible on email. Please drop us a line. Let us know. Otherwise, you'll hear a couple things from us today, this afternoon, in fact. You will hear from us. So have a great day. Enjoy where you are. And thank you, Terry, for being here. I appreciate seeing you.
All right, Angela, thanks for a great session. We'll talk to everybody soon.
Talk to you soon, guys. Take care.